Hello everyone, welcome to our video. The topic of our presentation is Peaceful Settlement of Dispute. This is the outline of the video. What is dispute? Dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between the parties. It may exist between states, between international organizations, and also between both of them. The principle of peaceful settlement of dispute. According to the Charter of the United Nations, it states that all the members of the United Nations are obliged to settle their disputes by peaceful means in a manner where international peace, security, and justice will not be endangered. Article 2 has stated the obligation of member states to refrain from threat or use of force, while Article 33 establishes the parties to any international dispute shall seek a solution by way of negotiation, inquiry, mediation, conciliation, arbitration, judicial decision, resort to regional agency, or arrangements or other peaceful means by their own choice. Hence, according to these three articles, disputing parties are required to resort to mechanisms provided under the Charter and refrain from threat and use of force. Means of dispute settlement are divided into two: diplomatic means and legal means. Diplomatic means involve non-justiciable, political, or non-legal issues. It retains control over the proposed means and entitled to reject or accept the proposed settlement, while legal means involve questions of law and results in binding decision for the parties. The type of diplomatic means of dispute settlement are negotiation, mediation, and good offices, inquiry, and conciliation, while the types of legal means of dispute settlement are international court of justice and arbitration. First, let us look into diplomatic method. Negotiation is a simple diplomatic means and one of the oldest and most used in the peaceful settlement of disputes between states. Negotiation is where parties that involved in the dispute settlement negotiate their needs and discussing the possible outcome for parties to reach without any force involved. Diplomatic negotiation is considered as the safest mechanism to resolve dispute, and it engages directly within the disputant. Maintaining bilateral or multilateral relationship by getting mutual benefits and pursuing their own interests are the important keys in negotiating. One of the characteristics of the negotiations is that they can occur at different levels, between administrative agencies and experts, ministries of foreign affairs, diplomats, or even at a summit or a conference. However, the most common level is between ministries of foreign affairs. Next diplomatic method is good offices. Good offices is a procedure where a third party involved to negotiate with the parties to bring solution to the dispute in a different ways. The profit in good offices only discussing with disputants separately, and if the negotiations continued, this profit did not involve unless the disputant of the parties asked to. In simple way, good officers offer the parties suggestion to resolve the dispute, but in a passive way, and it follows the need of parties only when needed. Plus, good officers are means to boost and conclude negotiations. Their features and functions are similar to those of the negotiations, enrolling them in the same category of diplomatic, informal, and non-judicial methods. In terms of purpose, the good officers only seek to start or resume negotiations. They end when the parties sit at the negotiating table. According to Joe Pintila, in his article regarding the peaceful settlement of international disputes, mediation was defined as the action of a third party, an international organization, or even a recognized personality aiming at creating the necessary atmosphere for the negotiation between the parties to the dispute and the direct provision of the services of the third party for finding solutions favorable to the parties. The key feature in mediation is the mediator. A mediator is an active participant in a process of dispute settlement between the opposing parties, and he offers an assistance, guidance, and help to both parties in order to understand all important points of their disputes. Mediation can be performed by representatives of a state or an NGO, by an international organization or its functionaries, such as Secretary General of the UN and its representative, or by respected and distinguished person. The next diplomatic means of dispute settlement is inquiry. International disputes often involve questions of fact. Inquiry is a fact-finding method conducted by an impartial and neutral third party. The third party can be other states, international organizations, international lawyer, and judge. Disputing parties appoint a third party to produce a finding of dispute facts and prepare the way for a negotiated settlement. Once the facts are established, the disputing parties will settle their disputes. Inquiry reduces the tension of disagreement as it identifies the causes and effects. Disputing parties are not obliged to accept the findings. Conciliation is a non-judicial settlement method assisted by a neutral third party called as a conciliator or conciliation commission. The disputing parties appoint a conciliator by agreement. The conciliator investigates the facts of the dispute and suggests the term of settlement. Conciliation is a combination of mediation and inquiry. It plays an adversary role and examines facts collected by inquiry. The terms of settlement suggested by conciliator are not binding for the disputing parties. The differences between inquiry and conciliation. Inquiry is the finding of facts, while conciliation examines facts collected by commission of inquiry, make recommendation, and give advice in bringing the parties to an agreement. The United Nations and regional machinery. Following the failure of League of Nations, a world organization was made with the creation of the United Nations in 1945 after the Second World War. Three main organs of the United Nations. General Assembly. The role of General Assembly specialized in the Charter Article 10 to 14. General Assembly may discuss any questions or any matters. General Assembly may make recommendations with regard to any such questions. Security Council. The role of Security Council specialized in the Charter Article 33 and 34. Security Council shall, when it deems necessary, call upon the parties to settle their dispute by such means. Security Council may investigate any dispute or any situation to endanger the maintenance of international peace and security. Secretariat. The role of Secretariat specialized in the Charter Article 97 to 101. Secretary General may bring to the attention of Security Council any matter, may threaten the maintenance of international peace and security. Secretary General shall act in the capacity in all meetings, and shall perform such other functions as are entrusted. The United Nations, a diplomatic forum in which persuasion, argument, negotiation, and a search for consensus are the means available for handling the international disputes. As at UN, there are a great variety of regional organizations as the instrument of dispute settlement. For example, World Trade Organization, African Union, European Union, Central American Court of Justice. Regional machinery often make a constructive contribution to dispute settlement. Regional machinery use their own resources to reserve its effort for inter-regional and intra-regional disputes. What is arbitration? Arbitration is a device for leaving the settlement of disputes as much in the hands of the parties as is possible. It can be conducted confidentially and can be quicker and cheaper than ICJ proceedings. The Permanent Court of Arbitration had been set up by the 1899 Hague Convention for the Pacific Settlement of International Disputes. Recent practice of the Permanent Court of Arbitration had been limited. There were only 43 attributions between 1945 and 1990. The procedures of arbitrations grew to some extent out of the processes of diplomatic settlement and represented an advance towards a developed international legal order. 3 characteristics of arbitration. Consent to jurisdictions. The cornerstone of jurisdiction of international courts and tribunals, including investor state arbitration tribunals. Some investor state tribunals set out consent as a condition of a so-called jurisdiction, ratione voluntatis. Consent must be clear and unequivocal, and the burden of establishing consent lies primarily with the claimant. The United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards requires that consent be in writing for an arbitral award to be enforceable. Selection of decision makers. Distinguishing arbitral tribunals from international courts relates to the legitimacy of decision makers in the disputing parties and the public. It concerns, more specifically, the selection and remuneration of arbitrators and judges in international law. In order of neutral third parties making binding decisions to be perceived as legitimate, they must be accountable in a way that does not compromise their independence to those who may be affected by their decision. Criterion of permanence. The characteristics is based on 2 related aspects. The first is institutional. It concerns the temporality of the judicial body and the security of tenures of its decision makers. The second aspect is functional. It concerns the mandate of these adjudicators and their role in the development of the law. The criterion of permanence is one of the aspects on which the analogy between domestic courts and international courts is the most tenuous, as shown by the examples of part-time appointments at the WTO appellate body and of ICJ chambers and committees. Element of arbitration. Consent, a prerequisite. Treaty of arbitration, institution, the law applied by arbitrators, binding force of arbitral award. Arbitration versus court, the utility of arbitration. The jurisdiction refers to the competence or power of the tribunal to decide the cases. ICJ, International Court of Justice. The court may entertain 2 types of cases: legal disputes between states submitted to it by the states involved, which is contentious cases, and requested for advisory opinions on legal questions referred to it by United Nations organs and specialized agency, which is adversary proceedings. Regarding the legal disputes between the states, the source of law that the court must apply are international treaties and conventions in force, international customs, the general principles of law, judicial decisions, the teaching of the most highly qualified publics. Moreover, if the parties agree, the court can decide a case ex equo et bono, which means according to what is equitable and good on the merit of the case. It is often used in international law when a matter is to be decided according to principles of equity rather than by points of law. Advisory proceedings. Advisory proceedings before the court are only open to 5 organs of the United Nations and 16 specialized agencies of the United Nations family or affiliated organizations. The United Nations General Assembly and Security Council may request advisory opinions on any legal questions. Other United Nations organs and specialized agencies which have been authorized to seek advisory opinions can only do so with respect to legal questions arising within the scope of their activities. Next, I would like to briefly introduce about IFLOS. The full name of IFLOS is the International Tribunal for the Law of the Sea. The International Tribunal for the Law of the Sea is an independent judicial body that established by the United Nations Convention on the Law of the Sea. It is to adjudicate disputes arising out of the interpretation and application of the Convention. The establishment of the ITLOS is to bring the system of dispute settlement of the United Nations Convention on Law of the Sea into full operation. In conclusion, there are various means and instruments used to settle international disputes peacefully without endangering international peace, security, and justice. Every method has its own function and characteristic in resolving international disputes. Thank you for watching this video.